Good evening, everyone, and welcome to Warren Publishing Group's Elder Abuse Awareness Continues. I'm Antionette Warren, and I'm founder and CEO of Warren Publishing Group, a Senior Advocacy Alliance, which provides information to seniors through a e-newsletter, through philanthropy, Speakers Bureau, and community outreach. And we're going to be celebrating our 10th year anniversary next month. Woohoo! So, as some of you may know who have been attending our presentations, Warren Publishing Group has really took upon every aspect of elder abuse to make sure that people know the different abuses and know that elder abuse is live and well, and we are going to stop this atrocity. I now would like to introduce our co-presenters for our series. And I'd like to first welcome, if someone is present with the Alameda County Care Alliance.
That is me.
Okay, Dr. Clyde Oden Jr.
Yes.
Welcome.
Thank you.
Yes.
I'm the assistant director, and Reverend Cynthia may join us a little later.
Would you like to make a comment with regards to what Alameda County Care Alliance is all about?
Yes, it'd be my privilege to do so. And thank you. One, congratulations on your 10 years of being on the case. And we very much appreciate that kind of dedication. The Alameda County Care Alliance works with persons with advanced illness, and we provide advanced illness care as a community-led, faith-based advanced illness care program with a holistic approach to addressing the needs of those persons that have advanced illness as well as their caregivers. We've been operating since 2014 and currently serve through some 42 churches, engaged in more than 300 pastors in and faith leaders, and serving about 1,400 persons. And often the persons we serve are older in our community. Some would call them prime time players. And we work to empower these persons to be able to make decisions about their life, decisions about their health care, decisions about how they should be handled in a time in which illness is becoming more and more a part of their lives. And we think we make a major contribution to the lives of the people that we're serving. We serve Alameda County, Contra Costa County, and San Francisco County at the present time.
Thank you so much, Dr. Odom. I now would like to introduce you to the National Coalition of 100 Black Women. We have presenting our Madam President, Maxine Hickman.
Good evening, everyone. Antionette, congratulations on your 10 years of advocacy. We've been working with you, I think, for 2 years now.
Yes.
But congratulations. The National Coalition of 100 Black Women is an advocacy organization, and we advocate on behalf of Black women and girls to promote gender equity and leadership development in the areas of health, education, and economic empowerment. And our vision is to see Black women and girls live in a world where socioeconomic inequity does not exist. We believe in gender equity, inclusion, respect, racial and social justice, integrity, and accountability, economic empowerment, and collaboration. And our membership portal is open. So if we have anyone online that's ready to work in this area, we invite you to go to our website and see some of the work that we're doing in the community and complete an application for membership. Thank you, Antionette.
Thank you, Madam President. And I am a proud member of the San Francisco chapter of the National Coalition of 100 Black Women. Thank you for partnering with Warren Publishing Group, Dr. Hickman, and also Dr. Oden, Alameda County Care Alliance. Thank you. Okay, so now I have the honor of introducing you to my partner, Jorick Gaines, who has been a presenter with us for the last 2 years in various capacities. He has over 35 years financial industry experience and has a holistic and one-stop approach to working with small business owners and families from every income level. He holds insurance licenses, life and health, and property and casualty in multiple states, and is a nationally registered investment advisor representative. You can contact Jorick by going to jorick.gaines@wealthwave.com. And for more detailed information, and I'll ask Jorick to put that in the chat. It was on the flyer. So I'm very thankful and honored that Jorick has found time to join me in trying to give, and not trying, but giving really important, critical, crucial information about, so people can not be victims of elder abuse by getting their business in order. Thank you, Jorick.
It's my pleasure, Antionette, and again, congratulations. You're a servant, a selfless servant. We appreciate you a bunch.
Thank you.
For those of you, we teach people how money works because it's not taught in schools. And most people have no idea how money really works. What we're talking about tonight is a big part of that, because there are too many families out there that have accumulated assets and even some wealth, and they haven't gotten their affairs in order. And instead of leaving a legacy, they leave a nightmare. So we are here to try and put an end to that as best we can. So tonight we're going to be talking about free wills and getting your wills in place. I just had a guy, got a call 2 days ago, 59 years old, passed away in his sleep. And they didn't talk about money, and his wife is now trying to figure out if he has insurance or what does he have that she can bury him with. And it gets under my skin. So that's all I'll say about that. Thank you again.
Thank you, Jorick. Thank you so much. So as a member of MoveOn, we partner with Freewill, who offers online services that has already empowered over 230,000 Americans to create their living wills. And so our first presentation today is going to be on completing your living will. So we are actually going to be going to the website, to the living will. And my Zoom administrator is with us this evening, as she always is. Thank you, Amy. So Amy, if you would share your screen, please, and what we're going to do is we're going to go through this will, and at the end of this will, you will be able to go later on freewill.com, and you'll be able to do your own will. You'll be able to print it out, download it and print it out. And then you can share this with your family and friends on how to make their will. Everybody needs to get your business in order. Thank you, Amy. Could you proceed?
Okay. So when you go to the Freewill website, this is the first thing you'll see. So you'll go to the button and on it, you'll fill in your name and your email address. And then save and continue. When you put in your email address, right, it'll automatically create an account for you so that if you can't finish it all at once, you go back to it. So as you can see, I'm in the login screen because I've already made an account. And you'll start with your basic details. You'll fill in your gender, your birth date, phone number if you want, and your address. Save and continue. It'll ask you about your marital status, the approximation of your assets. And if you have any questions about the question itself, you can go to the question mark on the right corner and click on it, and it'll explain to you more about the question it's asking and what they want from you. So you fill it in, save, continue. It'll ask you if you have any children, and if you do, you'll fill in their full name, and it has click to add another. You have multiple children. It'll ask if you have children underage. If you do, it'll ask you to fill in a guardian for them, like who will the child go to if you pass away. And it goes in order of preference. So the first person you add is the first one. If they're not available, you click to add another. And the second person is who they'll go to, and so on and so forth. Save and continue. Oh, sorry. Now it talks about pets. So if you have a pet, right, it'll ask you, you fill in their name, what species they are, and then it asks you how much money will you leave behind to pay for their veterinary costs, and it also asks who will take care of the pet after you pass away. And this is who will execute your will, right? It's also in order of preference. First name is first choice, second name is second choice. They'll fill in the name and the relation to you. So sibling, parent, cousin, grandchild, grandparent, so on. And this is the digital executors. Your digital executors' primary responsibility is to distribute your digital assets to the beneficiaries that you specify. In order to fulfill this responsibility, your digital executor will have the power to access, download, and back up digital assets, convert file formats, access to any devices as necessary to manage digital assets, to clear computer caches, and delete files. So by default, your estates executor will also be your digital executor, unless you want to appoint a separate digital executor and to decide to give permission of your digital executor to all your electronic communications, like your laptop, your phone, your computer, right? So next is, what do you care about? So Freewill is free to you because of the support of nonprofit organizations working on meaningful issues such as cancer research, human rights, environmental conservation, and education. Will you consider leaving a gift for a cause that's important to you? Click no thanks if you don't want to leave any gifts for charity. So basically, if you want to donate after you're dead to a charity of your choice, this is where you would designate. So for example, if I wanted to donate or leave money to the Save the Children organization, it would ask me how much of my residue estate will I leave to Save the Children, and then you would decide on what percent you want and leave a message if you wanted. So for the sake of this presentation, we'll just say no thanks. And this is the primary beneficiaries of a residual estate. A primary beneficiary is first in line to inherit property when you pass away. So it's basically asking you who will get your remaining estate when you pass away. You can choose to split it evenly among your children or other descendants, or you can create a custom plan where you would manually add each person with their full name and their relation to you, and you decide how much they would get, like what percent of your estate would they get. So say I put John Doe, my child, I want to give him 50% of my remaining estate, right? And then since I gave him 50%, I would have to add another person, right, to give the remaining 50%. And when you do the custom plan, the allocation, it has to add up to 100%. Right, so save and continue. The secondary beneficiaries of your residual estate is the people who, if the previous beneficiaries did not survive. So like if your children and the children's children did not live, these will be the second choice where your property will go to. And you can decide once again to create a custom plan or just leave it to charity. And you would add what charity you would give it to and how much they would get. And it asks for the name of the nonprofit, the IEN if you know, the address, and if you want to leave a message. We'll just leave it like that. And this is basically the summary of who would get your money. So to check if you made any mistakes, you would click edit and it'll let you do the process again to let you change it. And this is the specific gifts. Here you can choose to leave a specific gift in the form of real estate, vehicles, cash, or any type of item to particular individual or individuals. This section is completely optional if you want to provide wishes for the distribution of your residual estate. So basically, this is for if you want to give like your car to a friend or something, or leave them some money. So you would go to click to add property. You would choose one, say I want to leave my friend some cash, right? You would decide how much money they want. So like say 500, save and exit. And then this it says unassigned, right? Because you didn't appoint who it would go to. You would click the assign button and then you could choose, you split it evenly among the children, create a custom plan, or leave it to charity, right? This is basically like some extra, if you want to be more specific, right? So then saving to. This is your funeral wishes. Here you can choose to include wishes for your funeral and final resting place. The wishes you enter will provide instructions to your funeral executor, but please note that they will not be legally binding. It's recommended that you keep these instructions separate from your estate planning documents, as these instructions usually need to be acted upon quickly prior to a set asset distribution. So it's basically asking you what you want your funeral to be like. Like if say if you want to be buried in a specific place, what your gravestone be like, who to invite, the decorations, the flowers, stuff like that. And some people prefer to have donations sent to their favorite charity in exchange for flowers. So if you don't want flowers, you can donate to a charity of your choice. And you can also choose who will be carrying out your funeral and final resting place instructions. This is the asset list, optional. Non-probate assets, which include IRAs, 401ks, pensions, bank and brokerage accounts, and life insurance policies are typically held by financial institutions. Providing and attaching this information to your will can help your executive better handle your affairs. Note that designating beneficiaries for non-probate assets cannot be handled by your will. We will provide instructions for how to handle your probate assets at the end of your will making. So if you have any of these assets, you would need to click on it, say life insurance, right? So life insurance, what institute currently manages this asset, how much is it currently in there, and label it if you want. So yeah, next. So a no contest clause. A no contest clause is a provision that discourages challenges to your estate plan. It states that anyone who baselessly challenges the distributions you've made will he or she deceased you. In other words, they will not receive any gifts you left them. So you want to include your documents, click yes or no. This product is free because you work for a nonprofit working for meaningful issues. So this is basically asking you once again if you want to leave any gifts for charity. And then this asks you if you want to have 3 witnesses sign your will. Independent administration. Illinois, Missouri, Texas, Louisiana, California, and Nevada permit independent administration of estates, largely free of court supervision. This means that after an executor is approved and an inventory of estate assets is filed with the court, the executor can administer the estate with minimum further court involvement or supervision. For example, an executor can settle claims by creditors, sell assets for the payment of taxes, and distribute property to estate beneficiaries, all without court's insight or approval. Even if your estate does not currently permit independent administration, you can still include language authorizing it in your will if you like. That way, if your state law suddenly changes or you move to one of the states that do permit it, your wishes will be clear. So this is basically asking if you want court supervision for when people execute your will, or if you trust your will executor to follow your instructions. So life insurance. Life insurance can be provided through work or personal life insurance policy. Term life insurance can help loved ones cover your expenses if you're not around, like any leftover tax or debt repayments of final rights. Asking if you have any life insurance. This is a personal statement. So basically, if you have any messages, any lessons you want to pass down to your descendants, this is where you would write it. And then this is where you would review your responses. So basically check if any of these entries are wrong, or if you want to make any changes, you would click the edit to make the change for that section. So after you review it, save and continue. And this is where you would download your will, email your will, or whatever you want to do with the document. And that's all.
Thank you, Amy, for going over that will for us. So once again, what you'll be able to do after today at your leisure is go to freewill.com, and you'll be able to have access to creating your own will. You can download it, print it out, and put it in a safe place. Now, what a will won't do, Jorick is going to share that information with us now. After Amy, if you would put up that handout.
Yeah. What a will won't do. I guess we're going to take questions after this, Antoinette, is that correct?
Yes, yes. So if you have any questions up to this point, you can start putting them in the chat. And I would like to mention here, if I could, that Alameda County Care Alliance has changed their website address. So that is already in the chat. So please put your questions in the chat, and they will be addressed at the end of Jorick's information on what a will won't do. Thank you.
Well, thank you again, Antoinette. First thing I want to say about wills, if you have property, you want to get the living trust, which we're going to talk about in another session if you got the flyer. But wills are totally contestable, and you can put that clause in that Amy talked about. I'll just read through this because it's pretty comprehensive. But a will is a document of last resort to transfer assets. This is a Milwaukee attorney that said that there are a lot of ways to transfer assets that would preempt the terms of a will, and they give a couple examples, and some of those relate to marriage and ex-husbands and wives. there have been so many issues around that. I've seen so many people that, matter of fact, this happened recently where a lady had 2 annuities and she had her ex-husband on there and thought she had changed it. But anyway, that's a long story. But the bottom line, has she passed away, even if she had it in her will, the insurance company, annuity company is going to honor the beneficiary on that contract because they are contractually obligated. So here are some major assets that often fall outside of a will scope, along with the tips for getting them to the people or organizations you want. When it comes to 401ks, IRAs, pensions, the person or people listed as beneficiaries may end up receiving those assets, regardless of what your will says. Those state laws may sometimes intervene. I mean, we live in a litigious society. You can sue for just about anything. But a lot of that is contractually obligated. So that's because you've already told your plan administrator or investment firm how to handle the assets after your death, explains Portia M. Wood, a Los Angeles County estate attorney. There's no longer a need for probate interference, she says. This can cause sticky situations, such as when you want your spouse to inherit everything, but your ex-spouse is still the beneficiary of your 401k. Against your wishes, your ex may get those funds. Many ex-spouses are not willing to say, oh, I know it was a mistake. Let the current spouse have the money. Yeah, that's right. That's not going to happen, says Atlanta financial planner Camila Elliott. Another problem can arise if no primary beneficiaries are alive and no contingent beneficiaries were named. Then the recipient could be determined by the default terms set when the account was opened. And now, as in the case with retirement accounts, a life insurance policy's beneficiary listing, not your will, generally determine who gets the money. So again, you could accidentally leave a policy payout to your ex, but both insurance and divorce are chiefly covered by state law, which can vary. And it does vary because each state sets their own laws. So in contrast, private sector retirement investments are primarily governed by federal laws. Some states, Minnesota, for example, automatically revoke the beneficiary designation of an ex-spouse on a life insurance policy. I can tell you that's not the case in California. The rules can be complicated, so the safest strategy is to update beneficiaries on all insurance policies and investments after a divorce. You should not fall into the trap of trying to figure out which is a state account and which is a federal account. Just update all of them. A divorce agreement, however, might include a provision that an ex-spouse receives life insurance proceeds, notes Walney. In that instance, the policy holder should affirm that election with the insurance company once the divorce is final. Now, let's talk about bank accounts. If an account is titled as transfer on death, payable on death, or joint tenancy with right of survivorship, those designations generally override the will, says Reggie Fairchild, a South Carolina financial planner. Your account's signature card could indicate if any of these designations apply, and you can ask your bank to look up your card if you're not sure. For individual accounts titled TOD, transfer on death, or POD, paid on death, the beneficiary can go to the bank with proof of identity to transfer or collect the funds. Joint tenants with rights of survivorship accounts become the property of the surviving account holder, who need to show the bank a death certificate for the other account from the other account holder. Now, as I was saying, real estate, if two spouses own a property jointly with the right of survivorship, the property automatically passes to the remaining spouse without a court's involvement. Real estate can also be transferred outside a will in certain states, such as Wisconsin, through a transfer on death deed in which you name the beneficiary on the property. Now, here we are with trust. Okay, any asset in a trust not governed by a will, making trust another tool for distributing assets outside of probate court, which says, but after a trust is set up, you need to retitle accounts, change beneficiaries, or take other measures so that each asset you want into the trust will actually end up there. I just want to say one thing on that right now. We are in this refinance frenzy right now. And a lot of people that own property are refinancing. Lenders do not lend to an entity. So you have to take the property out of the living trust in order to refinance it. And in a lot of cases, people forget to put it back into the living trust, which means if they pass away, it could be a nightmare. So be aware that under the 2019 Secure Act, most trusts have lost the ability to stretch IRA distributions. I'm not going to go into all of this, but just real quickly, it used to be if you inherited your mom's or dad's IRA, you could literally take income for your life expectancy, but they changed that in 2019. So now, in most cases, those distributions need to be paid out within 10 years because the IRS wants their money. Because typically that money hasn't been taxed. Similar to the case with non-trust IRA, says Ed Slott, founder of IRAhelp.com. So, and you can look at the bottom and say, get right on the money. So fill out forms completely, use words precisely, don't be ambiguous, stay current, review your beneficiaries at least every 2 to 3 or 4 years, take care of your estate, and don't wing it, which is what too many people do. All right, so Antionette, if you want to open it up for questions, or if they have questions of me of any of those financial tools.
Yes, let's see. We have a question up here that's, do you need a will notarized?
No, it is not a requirement to have it notarized, and you don't record it either, but here's the suggestion. Don't put it in a safety deposit box. Some people are gonna have a revelation, because if that's where your will is and you pass, how are they gonna get it? But it is a good idea to maybe have somebody notarize the signature so they can know it wasn't made up. And I always suggest to people that they give a few copies to some people you trust, and maybe write on the envelope, only open at my death, and say, hey, look, this is my final wishes. I'm giving you a copy of it. Something happens to me, blah, 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 blah.
Thank you. There is another question. Does your spouse need to have a separate will?
It's a good idea, especially these days, because if you have a trust, it's a little easier. But if you're just writing wills, if you don't own property in California, if you own property, you need a trust. So that's all I'll say about that until our next segment on trust. But yes, I'd say yes, because especially these days where people are in their second or even third marriage with kids from a different marriage, you need to have a will and be clear on what your intentions are. Oh, and let me give a disclaimer. I'm a financial advisor, investment advisor rep. I am not an attorney. I'm not an estate planning attorney. So don't act on what I'm saying. I have to say that to protect my assets. So please consult with your legal consultant. I can give you some general information, and I do have access to attorneys if you don't have one.
Thank you, Jorick. The next question is, what if your kids find your will and living trusts, take copies because they are not happy with the living trust?
Surely that's never happened, has it? I can tell you it
Yes.
has. I'm from Baton Rouge, Louisiana, and my first girlfriend, her mother had a massive heart attack and died, had 3 properties, and she said to me, now I know my mom had a will, but you know, the first thing that happens typically is family ransacks the house and starts looking for cash and jewelry and the will or trust, which is why I said give 2 or 3 copies to other people so that when you pass, if they say, oh, we didn't have a will, we didn't find a will, hey, I have it. And then they can verify with the other 2 copies and legitimize it. But that has happened. It happens more than you know.
Okay, are there any other questions that anyone might have? So, Jorick, maybe you could just share information on your agency and exactly what you do to help with a will, and then we'll wrap it up.
Well, from the will perspective, we work with a few companies. We have a digital, of course, this is free. This looks pretty comprehensive, especially from the will. I haven't looked at the trust. We have a digital option for those people that want to do it that comes with some attorney advice. But the real thing is we try to make sure that people review their beneficiaries at least, you know, especially if you have a major event, somebody dies and, you know, you have more, you have an additional kid, you buy a property, you sell a property, you need to frequently update your will and your trust. And one thing I like about the digital versions is most of these digital versions you can update or change, or some of them, I should say, I don't want to say most, because if you go back, if you use an attorney to do it, and I'm not saying don't use an attorney, some people need to use an attorney. Some states' plans are really sophisticated with lots of assets. You need legal advice and pay the money. It's money well spent. Let's see, but pay attention. I mean, you didn't work. This is one of my pet peeves. I've gone through it personally, so I can tell you how it hurts and how it tears families apart. And you're pinning your closest relatives against each other, and you're never going to agree. You know, we couldn't agree. You know, I grew up with 4 siblings. We couldn't agree who was going to sleep in which bed sometimes. So you know you're not going to agree when it comes to money, and money changes people. So the first thing is to try to set up, as far as assets go, money assets, and make sure you have the proper beneficiaries. You can change your beneficiaries. However, if you're married, especially on retirement plans, you cannot change the beneficiary from your spouse, and I'm speaking of California, without the spouse's consent. And I mean written consent with a signature saying that I agree to let her change his beneficiary, let him change his beneficiary, because California is a community property state and your spouse's retirement plan is 50% yours. So if they change the beneficiary and you're not the person they changed it to, there could be a legal battle there. But we help guide people and really try to find out what their wishes are. You see the book in the background, How Money Works, Stop Being a Sucker. We published that in 2019. Last year was the best-selling personal finance book in the country. It's very basic, but it covers our 7th step is estate plan. You know, none of us work 30, 40, some cases 50 years to leave our assets to the state, to the federal government, and to some attorneys that don't have our last name or they're not in our bloodline. And that's exactly what's going to happen if you don't have your affairs in order.
Thank you, Jorick. We have another question. If your family has a trust from the parents, should adult children get their own trust with the S? If so, does it make sense to use the same attorney who handled the original family trust, or should we use someone different?
Well, I think most attorneys are kind of like doctors. They most attorneys, if they feel a conflict, they'll tell you to get another attorney. They don't want to represent both. And I've seen that situation. So that really is, kind of my pat answer. It depends. I say the first thing is make sure you're comfortable with the attorney. If you get that gut feeling that says something's not right, do what mama said. Follow your first mind. Follow that gut. You had that gut feeling for a reason. Go with it. But it depends on the complexity of the estate, to be honest. If it's simple, I don't see any problem using the same attorney. He's familiar with everything. But again, if it's sophisticated and definitely everybody shouldn't use the same attorney if you got multiple siblings. That much I will say.
Thank you. So if there is no more questions, I would like to thank everyone for coming to our first Complete Your Living Will. The next presentation will be on September the 28th, and it's Complete Your Durable Financial Power of Attorney. So we will go through the hands-on durable financial power of attorney, and you'll also be able to later go back and complete your durable financial power of attorney and print it out. And on October, in the month of October, we have 2 more presentations. October 12th will be Complete Your Beneficiary Designation. And on the 26th, it'll be Complete Your Revocable Living Trust. So please share this information with with seniors, your family members, caregivers, friends. Everyone is welcome to participate. Thank you, everyone, for coming. So many familiar names. Blessings to everyone.
Thank you, Antionette, for putting this on.
Thank you, Jorick.
I'm sure everybody appreciates it.
Thank you, Jorick, for your expertise in this area.
My pleasure.
Thank you, Dr. Oden and Dr. Hickman.